Good afternoon, everyone. Welcome to this afternoon's hearing. I'm going to ask Mr. Randall Dong to read the docket, please.
Good afternoon. We're here for the application of Daufuskie Island Utility Company, Inc. for approval of adjustment of water and sewer rates. And this is on remand from the Supreme Court of South Carolina. Mr. Chairman, we're ready.
Ready for oral arguments, right? We'll take appearances now. And please get to a microphone so they can hear you. I think we've got them close enough to everybody.
Good afternoon, Commissioners. I'm Tom Gressett here on behalf of the applicant, Daufuskie Island Utility Company.
Thank you. Welcome.
Mr. Chairman and Commissioners, Jack Pringle on behalf of the Property Owners Association's POAs.
Thank you. Welcome.
Good afternoon, Mr. Chairman, members of the Commission. Andrew Bateman on behalf of the South Carolina Office of Regulatory Staff.
Thank you, Mr. Bateman. Welcome. Okay, do we have any preliminary matters that we need to take care of before we begin? Okay.
I don't believe so, Mr. Chairman. I think they're all preliminary matters, given that this is an oral argument. But I don't think anything before we get to the actual arguing.
Thank you. Just giving you a chance. Okay. We'll begin with the applicant.
Good afternoon again, Commissioners. I'd like to begin by noting for the record that Hearing Officer Dong said we were all ready, or there was some agreement to that. I'm not sure I'm ready, but I think Mr. Pringle is. He has let us know where he stands. And I do think that it's interesting to start with Mr. Pringle's joking but also serious first statement that this is in some ways a preliminary matter. And I think the preliminary question is, we're back on remand from the Supreme Court, and the question for the Commission is, how does the Commission efficiently and properly address the matter on remand in a way that will hopefully prevent another appeal so we can bring this matter to a close? The utilities position is one of practicality and focused on efficiency. They have spent a tremendous amount of money on 2 full hearings, 2 full appeals, and now back on remand, and would like to do everything possible to proceed as economically as possible. That being said, we want the Commission to have the information that the Commission needs. We believe that information is already included in the record such that the Commission does not require additional testimony or documentary evidence, and therefore wouldn't require any additional discovery. Some of the other parties disagree with that position, indicating the idea that this is sort of a preliminary idea to decide, a preliminary hearing to decide how much information would be helpful to the Commission to proceed. Again, our position is that the record fully developed over the 2 hearings is adequate to address the concerns of the Supreme Court. The concerns of the Supreme Court on this most recent appeal are twofold. One, how does the Commission on remand apply an objective and measurable standard to the rate case expenses sought by the applicant? And then second, this question of the $699,000 excluded from utility plant and service, which has gone up on appeal twice but not been addressed, remains outstanding. For efficiency and practicality, having that issue addressed by the Commission would be helpful. There is likely to be some discussion about that question and whether the Commission has jurisdiction to hear it. I believe that if the commission were to fully examine that issue of jurisdiction, the law would indicate that there are certain times when cases are remanded from the Supreme Court with specific instructions that are limiting, that imply exclusion of another issue, or indicate some sort of limitation. In this instance, I think we look at the Supreme Court's two opinions in this case. The first opinion, there were 5 adjustments on review, and the court gave some instruction on 3 of them and referred to the instructions as, rather than addressing the 5 issues, they would address 3 allegations of error. 2 of those came back to the commission and were fully addressed by virtue of the Supreme Court's comments. The third issue that the Supreme Court dealt with involved the utility plant and service. And what the Supreme Court said was, we're going to address an allegation of error related to the plant and service, and then it went on to discuss the elevated water tank and that equipment. That issue came back down to the commission. The commission entered its new order addressing that specific reference, left outstanding this question of the 699, and that issue went back up on appeal again. In deciding the second appeal, the court conferred with the parties in oral argument. I'll say conferred. They examined us about both of those issues, plant and service and the rate case expenses, and then ultimately issued an opinion that indicated the framework applied on remand to the rate case expenses wasn't objective and measurable, and that the case should be sent back down for examination of the rate case expenses. I would assert that means that this commission is to apply the standard it applied the first hearing to rate case expenses, and it can consider that information on the record as it exists. With regard to rate base and this utility plant and service, the Supreme Court's silence on that matter doesn't constitute a ruling, and I don't think it divests the commission of jurisdiction. I also think if you look at both of the Supreme Court opinions, the goal is to address these questions practically so that they can be answered and so that the proceeding can either come to a close or move forward. If we don't answer the 699 plant and utility question, it will remain out there and subject to an additional appeal. The reason it's so important is $700,000 is a significant part of the utility plant for Daufuskie Island Utility. If they don't have a decision on that, specifically from the Supreme Court or a different decision from this commission, they'll have to continue to pursue that because they don't want to lose $700,000 worth of plant and utility based on the record that's currently under appeal, because we believe that, we've argued multiple times, that the record is insufficient to establish the exclusion. If the commission can address the issue of rate case expenses and address the issue of utility plant and service on remand, issue a new order, then I think it can move efficiently forward. The most efficient way to do that is based on the record as it currently exists, without supplementation of costly discovery or additional testimony. The other question that I think we probably should address briefly is the idea that if we proceed with a hearing that does not address the POA's concerns regarding additional testimony and hearing, that one of the suggestions, I believe, is that because the utility is pressed for these expenses, that we could just sort of end this case without really deciding and let them either pursue another filing, pursue the next case, do something in another proceeding. I don't think that's the efficient way to do it. I think that the commission has exactly what it needs in the record before it to make the decisions back from the Supreme Court. I am happy to, if you would like to talk about it now, or if you'd prefer to hear from the other counselors first, but I'm happy to talk about either of the adjustments, what's in the record. We are happy to present a proposed order that addresses those factual issues. Also, if after hearing from the other folks, you identify legal issues that you would like addressed in a proposed order, we're also happy to do that. We understand that this is a unique situation. We understand that at first glance, the opinion from the Supreme Court can sort of seem vague, but I think if we think about it practically, the two steps we've outlined here are the appropriate way to go. And I'm also happy to answer any questions now or later. All right. Thank you, Commissioners.
Thank you.
Mr. Chairman and Commissioners, Jack Pringle on behalf of the POAs. I guess broadly I want to cover two topics. One, the posture we're in following the Supreme Court's remand of the case, or second remand of the case, and then my client's view of the way forward in view of that posture and where it leaves us. The Supreme Court's decision that, as Mr. Gressett pointed out, did determine that the failure to follow an objective and measurable framework for consideration of certain rate case expenses, that constituted legal error and the necessity to remand, made clear to articulate in the opinion that the court was not addressing the merits on remand at all. What that means is, and Mr. Gressett made reference to this too, there are situations where a case comes back from an appellate court with instructions on remand that would say, this is what has got to take place as a result of this ruling. Generally, that takes place, and there may be exceptions to this, when the reviewing court decides a matter of law and then directs the lower court. For example, based on the case I cited in here, you, trial court, are limited to making a determination of damages. You're not going to make a determination of liability. That wouldn't take place at the commission, of course, but that's an example of when an appellate court says you're not going back for a trial de novo or a hearing de novo on the merits. You're going to go back and do something very specifically, something limited, something based upon the appellate court's ruling. That did not take place here. As a result, and when you remand without instructions, that is telling the commission that you will hear the case again. Now, I understand and agree that given that there have been 2 hearing records already, there are some possibilities for efficiency and to not have to, as they say, refight the Civil War or start again. But what that also means is that the Supreme Court didn't tell the commission what the result is going to be when it comes back. And more particularly, on the one issue that the Supreme Court considered, that of those rate case expenses and whether they were properly incurred and reasonable. The Supreme Court didn't say, when it comes back down to the commission, you will give them all the rate case expenses that they asked for. It said that you didn't follow a framework, the proper structure, the proper procedure in your decision to exclude those rate case expenses. So as I set out in the document that I filed with the commission last week, at the very least, if the commission didn't apply an objective and measurable framework on remand, then there has to be the application of a particular objective and measurable framework in this part of the case. And I disagree with Mr. Gressett that you could just figure out what the framework was that was applied in the first case before the remand, and then apply that to those particular rate case expenses. There were different rate case expenses on remand from those that were presented in the first case. I don't think it's as simple as to say, okay, we know what the framework was in the first case, let's just take it and put it on top of those proposed rate case expenses. As I mentioned in this document, I think the way forward is that which the commission articulated in its order on remand. The commission will recall that there was some, I don't know whether the term is exigency, but there was certainly a need on behalf of the applicant or a desire to have an order get issued, in part because there were rates that had been bonded and that bond was going to expire. And this is all in the testimony in the record, and the ORS said, well, we didn't necessarily have the back and forth that would normally take place when we look at proposed rate case expenses and decide, do they have these indicia of objectivity? Are they actual invoices that have enough information so we can evaluate them? And that's why the commission said, well, you could consider and submit those rate case expenses in your next rate case, given that there may not have been, we may have had compressed timeframes. Our proposal is that the commission do just that right now, to ask ORS and the applicant to confer and have DIUC have the opportunity to revise the invoices in question to address the kind of criteria or the inadequacies that the ORS raised, and then the parties could submit limited amounts of evidence or testimony on those particular invoices. And then presumably, or if that process went according to the ORS's review and what DIUC submitted, then those rate case expenses could perhaps be approved and could become part of a revised order on remand. Secondly, with respect to the assets, the plan and service, respectfully disagreeing with Mr. Gressett, it's not accurate to say that those were excluded from rate base. They have never been included in rate base. DIUC has proposed including that roughly $700,000 in plan assets in rate cases going back to, I believe, 2011. And the ORS never recognized those as actual assets being owned by DIUC. And so they've never gotten in such that they could actually be excluded. So it is true that the commission, given that this remand might very well be, it could be on the merits, it could be de novo, the parties could submit additional evidence on that question of whether those assets are properly assets of DIUC and then reasonably part of their rate base. But the Supreme Court's order, neither of the Supreme Court orders ever addressed those assets in any form or fashion in either one of those orders. So just by virtue of it coming back before the commission, likewise, doesn't direct that the commission do anything differently or call into question the commission's previous orders with respect to those assets, namely that DIUC has never shown that they were assets properly put on DIUC's books for purposes of its rate base. So I think that's where it leaves us. I think there's a way forward. By saying that it's a remand to consider the merits and to consider a de novo hearing, I'm not advocating that, again, that this all get relitigated again. My clients understand the importance of efficiency and going forward with this, but I just emphasize that the posture of the case that we're left with from the Supreme Court, that's where we are in terms of, unless it's remanded with instructions, it is remanded for the opportunity for the parties to submit additional testimony and evidence. And I do not think that the commission can rule on the rate case expenses absent additional testimony and evidence, because we don't know what the proper framework is, the objective and measurable framework is, and how that would be applied to those subsequent rate case expenses since the last case. I'd be happy to answer any questions that any of you might have.
Questions, commissioners?
I'm curious, before the last remand order, did any of the parties ask the Supreme Court to clarify their position?
On the most recent order?
Yes, sir.
My client certainly filed a petition for rehearing or reconsideration on the specific rationale for the determination that the ORS, that the way they pursued their remand, and specifically this allegation, and you can see it from the Supreme Court's order, which indicated that, well, the ORS must have been doing things in kind of an untoward way, because they didn't even include the original $75,000 that they allowed in the first case. And my clients, and certainly I believe ORS, certainly petitioned for rehearing on that, and it was denied. And denied in a relatively form order that didn't address that. So, but it was certainly raised, and that was one of the issues that left us in a kind of a strange posture to figure out, well, even if that is the case, even if that were true, which we maintain that indeed it's not, that the ORS did and the commission did include that $75,000 on remand. But even if you accept that as true, what does that tell us about what we do next in terms of what an objective and measurable framework is? And which what leads me to, well, that's why on remand you allow the ORS and DIUC to address those invoices and the ORS's contention that they were inadequate, and allow DIUC to correct them.
Mr. Bateman, has that occurred? Have you had any kind of discussion like that since the remand order was filed?
Commissioner Irvin, we've had, if I may step up this microphone. To dovetail on what Mr. Pringle was stating, we also filed the petition for rehearing of the court's order, and in their denial, there was no further clarification as to what that means. We've had no additional discussions with the company that I can speak of regarding a clarification on the objective and measurable framework.
Do you think it would be helpful to have those discussions?
Mr. Commissioner, if the commission believes that additional evidence in those discussions would be helpful, then ORS would be happy to participate in a proceeding of that nature.
Mr. Chairman. At this time, Mr. Bateman, in your conclusion, you're just saying that ORS is not submitting additional evidence in this case and has not conducted any new discovery or audits, and you're also recommending that the $75,000 be given back to the companies. Am I understanding you correctly?
Generally, Commissioner Whitfield, but if I may clarify a bit. So we discussed a couple of different things in the memo. Initially, I'd like to state at the outset that we don't believe, and I believe Mr. Gressett has made statements to this effect as well, we don't believe that the company can, or that the commission can award the company something greater than what the company noticed to its customers. Second, we'd ask that any recovery that the company is seeking, it bear the burden of showing in the record the evidence that would justify its ability to recover those expenses. To your specific question, Commissioner Whitfield, Mr. Gressett has indicated that they do not plan on presenting additional evidence. To the extent that the company does not present additional evidence, or that additional evidence is not presented in this case, ORS would not plan on introducing itself additional evidence.
Thank you. That's all I have, Mr. Chairman.
Just to follow up on that, are you contending that the record is complete?
Commissioner Irvin, again, we believe that that the commission could review the record and make a determination that is objective and measurable based on the record as it currently sits. That being said, we understand the concerns presented by other parties, and should the commission believe that additional evidence is required, then ORS would certainly participate in that proceeding.
Thank you.
Mr. Gressett.
Thank you, Commissioners. Briefly to address the issues that Council has raised, the utility agrees that when you advertise a rate, you are confined by the maximum. And you'll see that reference in multiple proposed orders in the pleadings that we have filed in this case. The way we think the Commission should address that is to first incorporate the 699, 631, and utility plant and service. Now, the reason the utility is candidly not interested in beyond the cost, etc., of additional information being submitted on that issue is because the Commission has never ruled on that 699. In 2011, an ORS staff member excluded it. DIUC objected. The case was headed toward hearing but was solved, with all parties reserving the rights to bring up their arguments later. So when it came up again in this case, along with the elevated water tank, ORS made some adjustments to utility plant and service. One of them was the 699. And in the initial hearing, as well as the remand hearing, the only evidence about that 699 and why it should be excluded was presented by original witness Ms. Gearhart, who said, I don't know, I wasn't involved in that case. I looked at the records from 2011, they excluded it, so I brought it forward.
Mr. Chairman, I know that Mr. Gressett is not attempting to testify or quote Ms. Gearhart, but I'd like it to be reflected that that's not actually what Ms. Gearhart said.
To be more specific, Ms. Gearhart testified that she, quote, carried forward, close quote, the 2011 adjustment. There was no other testimony or analysis to support it. When there were questions raised regarding the 699, I asked, and what research did you do to determine documentation of those costs of that plant and service? And the response was, those adjustments were simply carried over from the last rate case and we do not retest or retry anything that was approved in the last rate case. Now, that approval, of course, means approved by ORS, not the commission, because there weren't any findings on that.
Mr. Chairman, that's, again, I can, if you would like me to address this now, I'm happy to. I can address this after Mr. Gressett speaks. Which would you prefer, Mr. Chairman?
Just let him finish, then then you just address that.
Okay. To the extent that there is a debate about what was said at a hearing or how I have presented the same here, it's not my intent to do anything other than relay what's previously been relayed in pleadings. So if I have misstated something, we'd of course rely on the previous pleadings. But these are my notes that I was just reading from, so I'm pretty certain they're accurate. The point with the 699, 631 is this commission has never ruled upon that issue except in this proceeding. When it did so in the first hearing, we challenged it. When it came back down on remand, we maintained that challenge. ORS had opportunity, the POAs had opportunity to support why it should be excluded. There was no additional evidence provided on remand. We believe that the record as it exists does not justify the adjustment sought by ORS and also endorsed by the POAs. To bring the case back now and open the record to allow new analysis of that issue seems punitive, it seems unfair. The parties have had ample opportunity to brief that issue. With regard to the hearing being on remand, a hearing or a de novo hearing, as the commission will recall, when the case came back the first time from the court, it was sent back for a de novo hearing on all issues. In this instance, it was sent back down for a third hearing. I think the distinction is important. I think also with regard to how the commission addresses invoices and case expenses. The original analysis applied by ORS to case costs in this original proceeding is different than what was applied in the second proceeding and then ultimately endorsed by the commission order. And the Supreme Court said that second higher standard was punitive and unfair. If the commission, at the persuasion of ORS or the POAs, would introduce a new analysis, objective and measurable or not, it will not be what was applied in the first hearing. The commission should apply what was applied in the first hearing, or necessarily we're going to be arguing about whether it was punitive or not, whether it was higher or not, whether it was the same or not, and it won't be the same. And it's not fair for the utility to have to go through multiple appeals, not know what the test is, come back and find a new test the first time, and then another new test the second time, while continuing to spend money on rate case expenses that it doesn't know if it can recover. So practically, I think again, and efficiently, the way to proceed is based on the existing record.
Thank you, Mr. Bateman.
Mr. Chairman, I just have a couple of really brief things. For one, Commissioner Whitfield, I think I may have inadvertently failed to fully answer your question earlier, so I'd like to sort of circle back to that. You asked about this additional 75 being provided to the company. We recommend, just for clarity's sake, while we believe that the commission order was clear and that the 75 was awarded initially, what we recommended in our the most recent memorandum is that the commission grant the company the rate case expenses that it granted in the most recent order, 2018-368, I believe was the title of that order. But in addition to that, the commission also grant an additional $75,000 just to clear up any confusion, to ensure that no party is under the impression that the 75 was not included. So that hopefully answers your question, Commissioner Whitfield, a little bit more fully than I may have done so previously. Regarding Mr. Gressett's representations of Ms. Gerhardt's testimony earlier, I would just like to point out to the Commission that the court has stated that it is appropriate to use a previous order or previous metric as a baseline when going forward. That's exactly what Ms. Gerhardt did previously. She used the previous rate base as a baseline moving forward, and that is sort of to Mr. Pringle's point earlier. Sorry, I think the mic may be cutting in or out. But to Mr. Pringle's point earlier, the complete exclusion of the $699, which has never been included, and that is explained by the baseline manner of pulling rate base forward.
Thank you. Mr. Pringle.
Very briefly, 2 points, and I have to, again, respectfully disagree with both Mr. Gressett and Mr. Bateman in terms of the proposition that the record is complete with respect to the rate case expenses. And the reason I say that is because, well, even though we can agree that the Supreme Court said that on the remand that there wasn't an objective and measurable framework that was applied with respect to those rate case expenses. But I continue to maintain that we don't know what the framework was that was applied in the first part of the case. And more specifically, and I'm not so sure anybody could answer the question of how you apply that framework, whatever it is, to a separate batch or bundle of proposed rate case expenses. That even if the commission were inclined to do that based upon the record, my view of that is what that would be tantamount to was a wholesale approval of every rate case expense proposed by DIUC, which is not what the Supreme Court order directed the commission to do. It did not direct the commission to accept every proposed rate case expense. It said to evaluate those rate case expenses under that standard. I don't know what the standard is that was used in the first part of the case such that you could, like I said before, apply one to those particular expenses. Then finally on, and Mr. Gressett's a very good attorney, and we all do this when we get a chance to, is to do what's called burden shifting, where the idea that it was incumbent upon the ORS or the commission to try to poke holes in DIUC's proposed $700,000 in a utility plan as part of its rate base. But as the case law on this makes clear, it's incumbent upon DIUC in the first instance to demonstrate that those are indeed assets that it owns and to demonstrate that the price that it puts on the books for those assets demonstrates that they are the assets of the company. And that's never been done in any of these cases where it's been presented to this point. So it's not accurate to say that it was pulled out. It was never demonstrated as assets that were properly on the company's books in the first instance. And likewise, as this colloquy, well, I don't know whether is it colloquy when it's between two attorneys, or a back and forth, sounds like there needs to be a hearing if there's going to be a determination about those, that $700,000 in assets. If there's so much divergence on exactly what it's, was said one way or the other. That's all I got.
Mr. Gressett.
Thank you, Commissioners. With regard to this question about what framework was applied originally to the expenses, according to the ORS testimony in that case, ORS, and I'm quoting, felt, close quote, that $75,000 was an appropriate number. That's what's in the record about what ORS did the first time. And if you'll recall, the way we got sort of jammed up in the first appeal is because ORS and the POAs brought you a settlement agreement that ultimately was found reversible by the Supreme Court. In that settlement agreement, and then the order adopting it, there was question about the amount of rate case expenses of $75,000, and the reference was made to that was the amount in the last case. So when the court issued its original order, it said $75,000 for the current rate cases in the amount of $75,000 for GA's preparation of the application, developing rate models, calculating test years, etc. That was ORS's recommendation in that case. There's testimony where Commissioner Fleming asked an ORS witness about why are the current rate case expenses of $75,000 included in this case exactly the same as they were in the 2011 case. And the witness, Ms. Gerhardt, responded, because ORS felt it was appropriate to limit rate case expenses to $75,000 for the current proceeding. Now, I'll submit to you that there is very little more than that in the record about how it was determined. Hence, this is our problem. Having gone up on appeal twice and coming back down, if the commission were to revisit the 5-point tests or analysis that ORS applied on remand, it will likely result in something very different than when ORS applied its feelings. I don't know how we fix that, but I do think we have to be careful that we don't create a situation where DIUC is continually coming back and putting evidence before the commission and ORS to consider first because ORS hasn't worked out how it wants to review that evidence. Secondly, with regard to the burden shifting on the 699, 631 utility plant. As the commission knows, utilities are entitled to a presumption of reasonableness for the expenses they submit. We've debated this before here and before the Supreme Court. The utilities services case says once challenger, whether that be the commission or the ORS or the POAs, raises a specter of imprudence, then the burden of production shifts. Now, a specter of imprudence is important because it implies something nefarious or something improper, and there has been no allegation of that in this case. So it's the utilities' position that the burden does not shift by someone questioning an expense. The burden shifts by someone establishing the specter of imprudence. In the utilities case, it's also important to know that in that case, there was a debate about whether improvements and capital expenses were actually made in specific neighborhoods or not. And complainants had said, look, I live in that neighborhood that they're telling you they put up new equipment in and I don't see it. All right, that's the specter of imprudence, not what we have in this case. The commission's been very patient. I'll answer any more questions or let Mr. Bateman take over.
Okay, Mr. Bateman.
Mr. Chairman, if I may, I hate to belabor this point, but what Mr. Gressett just read regarding the testimony of Ms. Gerhardt was in response from a question from Commissioner Fleming. Other aspects of Ms. Gerhardt's testimony, specifically regarding rate case expenses, stated that ORS verified the operating experience and rate base reported by DIUC in its application to ensure was supported by DIUC's accounting books and records, that ORS tested the underlying transactions in the books and records for the test year to ensure that the transactions were adequately supported, had a stated business purpose, and were allowable for rate-making purposes, and ORS made adjustments and recommendations as necessary. I wanted to point that out to indicate to the Commission that ORS's review then and now did contain objective and measurable standards and were properly applied to rate case expenses as presented by DIUC.
Thank you. Commissioners, any questions? Anything else from the parties? Okay. Thank you. I'm going to turn it over to Mr. Dong.
Do the parties have any suggestions as to proposed orders? Mr. Gressett?
Thank you, sir. Mr. Dong, I believe that based on the arguments we've presented and those included in our recent memorandum, that the utility could be prepared to submit a proposed order that addresses the two issues on remand and initiation of the new rates at the Commission's pleasure.
It might not surprise you to learn that the POAs have a different position on this. I think my client would be prepared to submit a proposed scheduling order that the Commission could consider if it were to move forward with a remand consistent with the way I've articulated. I don't know how I'd throw the case law I like in a proposed scheduling order, but that's my problem. But I think that is certainly something my clients could do.
And again, Mr. Chairman, members of the Commission, ORS is, we will present proposed orders. If you would wish to not proceed with an additional evidentiary hearing, however, should you desire additional evidence be put into the record, ORS would present a proposed schedule if that's what the Commission would like.
Risk of, I would happy to be willing to submit something. I would submit that it may be, and this is obviously up to the Commission's discretion, that there may be a threshold issue about exactly what fork in the road to take, but that could be elucidated by what the parties submit.
I think that a more complete memorandum with regard to the threshold issue from all the parties would be useful. And then we can go from there, I suppose. If that's...
Certainly, sir, and the threshold issue being what to do now that we're back on remand.
That's right. That's right. And I think that is there a particular time frame in which which the parties feel like they need to produce those orders?
We can be flexible.
Well, do y'all need transcripts?
Probably, yes, sir.
Okay. Well, if that being the case, why don't we say 2 weeks from the time the transcript is ready?
Certainly.
Acceptable to everyone?
Yes, sir.
Thank you.
That works for the POAs.
Okay. Thank you. Okay. Thank you all for being here and for your arguments? And commissioners, anything else anybody wants to ask? Thing we need? Not? Thank you, and we are adjourned.